two parts. The first part relates to the vote given by him in the parliament. Anything said or vote given. The later portion which comes after end, after the comma, talks about liability with respect to publication by or under the authority of either house of the parliament of any report, paper, vote or proceedings. This later portion talks about the liability with respect to publication, etc. The first part talks about the vote as well as what is said. There is a distinction there.
Sorry to interrupt. Also, member of parliament versus person. First part is member of parliament. Second part is person.
No person shall be.
Person. So therefore, there is a clear distinction there. So whether with the expression in respect of attached to the first part is a question, perhaps that just came to my mind.
Lordship, please, Manoj.
That is one thing.
Lordship, please.
Does it attach to a pristine situation where a member of a parliament says or votes in a parliament? This has to be read in consonance with the first sub-article 1. Maybe there is perhaps a distinction there because, as they say, publication also,
Yes, Manoj.
and what is published with respect to the proceedings of the house also attaches some amount of immunity. That is what is said.
So the Lok Sabha debates, the Rajya Sabha debates.
There could be something, yes, Manoj.
And that will also attach to a staff of the legislature. The Secretary General of the Lok Sabha,
Yes, Manoj, the printer and publisher also.
Yes.
who will publish a report of the text of the proceedings in the parliament, would be equally immune because no person shall be liable in respect of the publication.
Therefore, the use of the word person,
Person.
because they are
Much broader.
expanded beyond the member concerned.
That's right.
There's a long English parliament.
Private public.
Right. That's by or under the authority. Something which is an authorized publication of parliament.
So which is that expression which connects, so to say, as the later part uses the expression in respect of, so far as the first part is concerned?
Yes, Manoj.
That's the question. That's a question.
Lordship, please, Manoj.
But otherwise, the other principle that the concept, the activity of corruption, which occurs outside the house, has got nothing to do with what is said and the vote which is being made in the parliament. That's the first part of it. But what, according to you, controls that,
Yes, Manoj.
the first part?
I'll read the sentence again. I'll read the clause again. No member of parliament
My question was slightly different.
Lordship, please, Manoj.
So that consequence of the speech made, consequence on the publication made. These are the only two conditions.
Lordship, please, Manoj. He doesn't-
Anything happened prior. No, not
That is where I'm,
authorized.
that is where in respect of comes for the,
I'll give you one more. Suppose a bribe has been taken by a member of the legislature for casting a vote in a particular manner, for making a speech. A court cannot therefore say that please invalidate this vote because it was motivated by a bribe. Suppose a person is convicted for the offense of bribery. Can a court say that therefore that vote should be excluded in computing the parliamentary majority? Suppose 20 members of the legislature are proved to have accepted a bribe. That vote is still a valid vote,
Lordship,
cast in favor of or against the motion.
Contextualized. Clearly, it is contextualized in the first part as well as second part when they use that in respect of a vote and what is said and in respect of what is published.
Lordship, please, Manoj.
Both are very clearly contextualized.
Lordship, please, Manoj. And bullets, in my respectful submission.
You can't say impugn a resolution passing a legislation or passing the budget on the ground that any of the votes which were cast
To pass the
were
finance.
vitiated by a criminal wrongdoing.
If that be so, if I may.
But that immunity which attaches to the vote which is cast does not attach to the crime which takes place independent of the casting of the vote or the rendering of the speech.
My respectful submission is, if the crime, the anterior crime, so let us assume minutes, and that is a matter of law minutes, there can be no two views about it. That the offense.
Let me put your argument at its best, at the highest, that the anterior crime of accepting a bribe for casting a vote or making a speech is integrally related
Lordship,
to
please.
the casting of the vote or the making of the speech.
That is my argument, minutes, and that is
And
my.
once both are integrally related, according to you, the immunity must attach to both.
In respect of,
That's the submission
Justice
there.
Narasimha's
That's the
question
heart of
also,
your
And the reason of highlighting what you have said of in the previous quotation of Blackstone is as it becomes necessary because of the reason that the executive
Lordship, please.
has a control over the members through some manner or the other. So therefore, the need for an immunity to
Grateful.
extend even to that.
Grateful.
That's your argument.
I'm grateful. And apropos, the observation.
We'll just elaborate what Chief is saying is this. In a case where, let us assume there's a bribery, voting takes place. Then on the question of validity of the vote, a decision is made within the parliament, that cannot be questioned.
No, it cannot. That undoubtedly cannot
To
be.
that extent, there is a casual connection,
Lordship, please.
notwithstanding that. But other things they stand apart. The criminality stands apart. That has got nothing to do with the parliament.
But that is where my argument that in respect of.
To that extent, the parliament can, the house can go into whether bribe is there or not, whether vote is there or not. To that extent, it can go into. To either validate or invalidate the vote, it can go into.
Lordship, please, but.
Now, in PV Narasimha Rao itself, the no confidence motion was defeated, right?
Yes, ma'am.
The court couldn't have said that the no confidence motion has to be now, you have to be now reviewed. And we will therefore now see whether the new no confidence vote was passed or otherwise by excluding these votes of persons who had improperly voted in favor
No, it's.
or against the motion.
There are two things, Mr. Ramachandran, that not voting is different and voting consequences are different is one aspect of the matter. Another aspect of the matter is the scope and extent of the immunity.
Yes,
That we need to balance the constitutional intendment of to what extent the constitution intended that the immunity must be extended in the context of speech as well as the vote.
Lordship, please.
How deeper it is depending on what kind of a mischief could happen with the executive intervention. So that's a matter of interest.
Lordship, please.
Yes,
And
just to expand this, what we are saying, it can at best be restricted to the business which the parliament expected to transact. Nothing more, as Manoj has said, let us take some murder takes place. Now, can we say that parliamentary privilege?
no,
We're trying to take
Yes.
very larger proportion. Then nothing can be done. Supposing some decision is taken, it can be questioned.
it can be, Lord.
So it can be only restricted to the freedom of speech and expression.
No, there always has to be a nexus with an MP or MLA's work or duty as an MP or MLA, minutes. And this is without minutes. I'm not going to my later submission that voting for Rajya Sabha also, not just legislative voting, is also part of the work of an MLA, but it has to be connected with that. And therefore, apropos the observation of the learned Chief Justice as to whether in respect of can be stretched, that was my Lord the Chief Justice's observation. There, my respectful submission is, it is not a question of stretching. The question is, can in respect of be restricted? Can in respect of be restricted? We are not stretching. The language is plain and unambiguous because there is a nexus, there is a causal connection. Then can it be restricted or whittled down? Because it is a crime of a particular nature, which is morally abhorrent. My respectful answer on the plain language of the Constitution is no. It can't be whittled down. We are not expanding in respect of, we are unjustifiably restricting in respect of, which ought not, to be done.